Welcome to INN's Advocate. INN's Advocate is a platform for lawyers having less than 5 years of practice. Today we have with us Advocate Sumit Rajkumar Parchani. He holds an MCom degree from the University of Mumbai and he graduated in the year 2017. He graduated his law from the University of Mumbai in 2020. He is currently pursuing his masters in law from University of Mumbai. He practices in the region of Kalyan, Thane and Bombay High Court. His areas of practice are civil law, criminal law and medical negligence cases. He appears across various authorities with regards to medical negligence matters. Today, Advocate Sumit is going to speak on insights into medical negligence. So without wasting further time, I would request Advocate Sumit to commence with his lecture. Thank you.
The topic is related on the inside of medical negligence. The medical negligence or the clinical negligence is defined the failure by the healthcare professional to exercise the reasonable standard of the care. And further we go through it when the doctor failed to do his job and with the almost care the result lot of harm to the death to the adverse condition. The doctor medical practice is said to be a medical negligence or to commit malpractices. The difference between the medical negligence and malpractices. All medical malpractice are medical negligence, but all medical malpractices are not a medical negligence. Let we discuss what the meaning of medical malpractice. All the intentionally riskless on action by the medical professional that the result of injury to the patient. The medical malpractice is more serious charges than the medical negligence. Let we consider the common example should be considered for the medical negligence has to be there. Let we discuss upon that. The presumption of to be wrongly mediation on the administration of the drugs that the harmful to the patient. First, their example are there. Every physician are prescribed the drugs to the patient. As per that, the prescription, the drugs may be harm to the patient. It may be the drugs are maybe illegal, which are not allowed to the government of the medical. As per that, the act are described in the as per the act. The careless partition and care and the negligence in the childbirth. Third, surgical error. Maybe the part of the doctor may be surgical error by the doctor at the time of the surgery. Second, the failure of the treat. Unnecessary surgery, wrong diagnosis, delay of diagnosis, lack of info, misdiagnosis, hospital negligence, and the living surgical equipment in the body. The most of the time we see that the negligence at the time of the doctor doing the operation, at that time the surgical equipment in the body has been living. The failure was to follow undiagnosed condition the like the heart disease, birth injury, hospital negligence, infection, undiagnosed the condition like the heart disease, anesthesia administration. That's the most important thing. The anesthesia is the hardest part of the in the field of medical. If the anesthesia is more than as per the country where thing is simple, the fact is very risk act. The liquid is the form at the time of just one extra drop of anesthesia is called can be lead lifelong. The person can be go in a coma. If the in simple way if the anesthesia was overdose, it may be impact to the person maybe go to the coma. That's the main point. If the doctor who have a different in the field that they giving the anesthesia, they giving a different who give the anesthesia. Let we go through the further, which we go through the history of the medical negligence, which we should know what the history of the medical negligence. In 1754 BC, Hammurabi Code, the medical malpractices and the idea of the doctor, the being the responsible to their action, date back thousands of the year back. In Hammurabi Code, is the earliest record of the law code there is a section to be for the medical mishap. The court said a doctor should be punished if the doctor make it the mistake causing harm during the surgery. Is the first. And second, the 5th century BC, Hippocratic oath. Hippocratic oath is just something that the doctor been using the time, ancient Greek, to show to behavior, to show the ethical behavior in a practice. The way of death, the sure to has the multiple version of the year to boil down to not to harm to the patient. The many modern countries still consider that the practice is going on. In 1734, the first record of medical malpractice case. The medical malpractice case in 1374, Stratton, with the surgery tried to the repair a human mangled hand. The human claimed the surgery should be cured. After the procedure still was deformed. The case was dismissed by the procedure of ever. But the just set the ground the rule many future cases. The just said the physician could not liable for their medical negligence, but the proper treatment it could be liable just because it not be cured by a patient. And the third and the fourth, the 1794, the US had the first malpractice case in the US. At the US plaintiff, the doctor promised to the operation successfully, but the opposed. The plaintiff wife died. Due as a result, he won the case, received a 40 English pound. Let's go through 1847. The American Medical Association is founded. The American Medical Association currently is the largest organization of the physician and the medical student in the USA. The resolution by the Dr. Nathan lead the formation of association. The 2 years later, they went to uniform standard. The medical education, training practices as well as the world's first nation code of ethical medical practices. Let's go through the 1835 to 1865. The UN has the largest increase the malpractice case is going on. The 19th century, the largest majority involved the fracture, dislocation with the less perfect result. The lawyer claimed the doctor did not use the proper skill, delegation, may physician trying to save a limb and instead of them, the common practices at that time is going on. 1970, the big settlement lead to the state of passing the reform law. The court being punished, published the standard medical malpractices awarded in 1970. The lead one of the fastest growing period, the money being awarded to the patient. The almost every state passing reform law and try to keep doctor the premium insurance premium down. Some of the state of California passed the law cap amount of certain type of damages. Let's go through 1980. The dramatic malpractices lead to. In 1984, the 18-year-old admitted in New York hospital to treat the two residents. The condition of worse and she died. And father sued for claiming the doctor overworked at negligence. He won the case in 1989. The New York passed the law. The limit amount of the work resident and the doctor could work laying the groundwork for the national-wide reform. And in 2017, the malpractices today has been increased day by day. The safety of the patient should be cared. The extension of medical practices history timeline, the doctor make a mistake. Over 6% of the doctor responsible for the 6% of the doctor are responsible for about 60% all malpractices payment. Surgery error, leading claim and impatient incident in 34%. Overall, the cost of medical malpractice in US is around $5.6 million according to the data. And India is 5.9 million medical malpractices filed annually. Around increased by 110% over the time and medical negligence increased by 400%. Let we go through the consent. What are the consent which will require for the doctor to perform the surgery at the time of surgery that need to be? First should be a valid consent from the party. The doctor must be a consent from the patient before completing a treatment procedure. The doctor at the time of consent to take a consent have to sign from the patient who taking a sign that I am ready to take a surgery for that. It's the procedure for the death procedure. The consent is important for the death. Consent is supposed to take in a doctor to perform the procedure. Whoever is the must place in the Indian, the regulate the nurse to save a doctor time to perform a need information, the procedure for the possible complement in the language of the patient to understand. First, we have to go through the consent which are to be there. The consent must be taken from the patient himself. The patient should be a capacity to competent to a consent. The consent to be a free and voluntary. The consent to be informed. The consent should be proceed specific. Consent obtained during the course of surgery is not acceptable. The consent from the blood transmission. The consent for examining or observing a patient for the education purpose. Fresh consent should be taken to repeat the procedure if there anything to be a surgery or by anything else, or the surgery consent is not sufficient to cover the anesthesia care. Patient have a right to refuse the treatment at the time of treatment. The persons have a right to refuse the treatment. Unilateral exercise consent to be avoided. Witness consent are legally more dependable. The consent are to be a proper documentation. The consent are withdraw his consent anytime. The consent are illegal, procedure invalid. However, often a valid consent, the consent are format should be there. Let me discuss about the first from the consent. The patient should have a capacity to competent to consent. As per the Indian Contract Act is clearly specified under section 11 of Indian Contract Act 1872. The person, he must have a age, he have to attain the age of majority, he must be a sound mind, it not be disqualified by contracting any law which the subject of illegal age is given by the valid consent under section 18 years. The child is 12 years can be give a valid consent for the physical examination. The prior to the performing very procedure of the child is less than 18 years. It adverse to take the consent of his person, parental responsibility to be taken their care as per that. The consent to be a free voluntary. As per the Indian Contract Act 1872, the consent to be a free consent, coercion, misrepresentation, mistake and fraud. And consent should be informed. The person doctor who ever doing a surgery should inform to the patient what going on, what the step we be taking, so that the patient will be know about everything about what we have to do. The consent for the blood transfusion, where the blood transmission specified the written should be taken. Exemption, if the emergency at the time of the patient have anything, so at that time there is no need for the consent is required, because we have to save the life of the patient. That is the important thing for the medical in the. If the fresh consent should be taken from the repeat procedure, if the procedure must be obtained, every surgical procedure including the re-examination procedure and the so and so. Dr. Salika Shah, in the surgery, surgeon was found deficiency in a service, was liable for the compensation. He had to perform exploration surgery without written consent from the patient. The most important thing in the consent is are there. The surgery consent is not sufficient for cover the anesthesia care. The surgery are ill capable to discuss the risks associated. Anesthesia informed the consent anesthesia must be taken. The anesthesia provide has only he can impart anesthesia related necessary information to be explained to the patient, and it may be a document by the anesthesia on the surgery. The consent of the handwritten note or the any separate anesthesia, the consent form is necessary for the patient to be signed. And the further we go through, and the patient right. The patient have a right to refuse the treatment at the time of the treatment, the patient have a right to refuse the treatment because he not want to further proceed for the treatment at the time of surgery. The consent should be in proper at the time of even organ transplant. There should be a necessary, the video recording is to be done. At the time of video recording, the consent is process also be done to prior to consent. There should be a documentation, the commonly done, the organ transplant procedure. It the consent to be signed by the patient admit without any signed authorization. It can be claimed that the procedure would not be consent to. The patient has the free to withdraw the consent term at any time, have a right to them and go through the consent in a relation to the medical research. The consent to be taken from the patient from during the drugs trial. The research should be as per the Indian Medical Council of Medical Research guideline. Otherwise, it should be a constructed as a misconduct. Let the consent in a relation to the medical research. The consent taken from the patient for the drug trial for the research should be as per the Indian Council of the Medical Research the guideline. Otherwise, it shall be a considered by the misconduct. The further we go through the medical, who are responsible for the medical negligence, that we have to know. Where the first the doctor or the hospital, other the healthcare professional. The doctor are liable for the own action, but can also held liable for the action of other certain situations. Example like the junior doctor involved in a surgery. They are responsible for seeking the advice, senior doctor. The senior doctor does not provide the proper advice, they may be liable for the injury caused by to the patient. The hospital second, the hospital is liable for the medical negligence to fail to provide the safe environment for the patient. This could be include the issue or malpractice manufacturing equipment, incompleting staff, inadequate accommodation. Other health services professionals are held liable for the medical negligence. Let we go to the expert opinion. However, the no expert medical evidence is presented to be support to claim a negligence. The commission observed the medical negligence case are the expert evidence crucial are noticed. The Supreme Court, the Justice, the S.K. Junjunwala, the said the evidence helped to determine the fault. The negligence of the doctor, in this case, the recent judgment has to be given. The negligence only if the doctor lack of qualification or expert treatment. Despite the top court made the observe the sittings aside order of the National Consumer Registral, which had to be lead the doctor negligence. As per the bench of the Justice P.S. Narasimha and the Pankaj Mithal, that be a second judgment which we have telling to you. On the 25th October, the bench of the Supreme Court on the Friday held the liable the negligence is on request of the qualification, skill, failure, exercising and reasonable expertise during the treatment. As the bench of P.S. Narasimha Rao and the Pankaj Mithal said the reasonable care expert, the medical professional, was extended to render the patient unless the contrary provide. It would not the case of actionable negligence. The medical professional held liable for the negligence only when the not proceed with the request of qualification, skill, fall, exercise, reasonable skill with the possession is given the treatment, the bench said. The top made observation of or either with the setting aside the order of NCDRC, which said the doctor negligence. According to the complaint, the minor diagnosis, the disorder in the left of his right required a minor surgery, which to perform in 1996 by the doctor. The complaint allegation, the physician diagnosis on their son could have been cured by the minor operation as there is no defect in the boy eyes. The procedure is to state the required slightly lifting the eye, left eye, the making a correction and compromise with the eyes, right side eyes. Doctor, however, the accused bothing up the procedure with the decorate the boy condition post surgery. The complaint there, the allegation of medical negligence, the was dismissed by the state consumer redressal commission. The above decision prefer the appeal before the NCRD, and the NCRD paying the compensation of rupees 3 lakh and 50,000 towards the medical negligence treatment. Further, we go to the complaint move to the NC against the NCDRC and observe the established negligence by the doctor. The bench have the decorate the patient condition the post surgery was not necessary initiate of the surgeon being improper or inappropriate. In this case, the surgery treatment is not necessary that every case condition of the patient would improve the surgery is successfully satisfaction of the patient. It very possible that the some rare cases complication of the such near nature arrive that itself does not establish the actionable negligence on the part of medical expert, the bench said. Further, we go to the case law of the case law. Second, the Allahabad High Court. The Allahabad High Court case under criminal revision number 3995 of 2004 decided on 23rd September 2011. The criminal as per the CRPC section 200 and 203 and 204 and 202 of said of CRPC and the IPC of the section 279, 304 and 304A the complaint. The summoning the expert evidence contention at the state of summoning the magistrate have a no jurisdiction to summon any expert evidence on his own record. The present case of criminal medical negligence allegation of the doctor did not treat the wife complainant properly has the effect course. The prosecution of the professional like doctor should not done without obtaining a pure medical opinion regarding their medical negligence. Regarding their negligence, unless the body expert come to conclusion the medical negligence, criminal medical negligence of a doctor, he should not, cannot prosecute for the case. Let we go to the third case of National Consumer Dispute Redressal Commission at New Delhi as the first appeal of number 245 of 1997 decided on 16 December 2005. The Consumer Protection Act section 21 clause A subclause 2 appeal against the dismissal of the complaint allegation of medical negligence the surgery cure to appeal and appendix allegation of overdose of anesthesia unqualified person the no specified evidence by the medical expert OP denying the negligence the state commission holding for the allegation of medical negligence no that evidence in given. Whether is correct? Yes. The result is appeal dismissed. Let we discuss on the National Consumer Dispute Redressal Commission. As per that the original petition number 147 of 1997 has decided on 9 February 2007. The Consumer Protection Act section 21 clause A subclause 1 the before 2002 amendment the complainant to the National Commission about the medical claiming of rupees 25 lakh compensation, the eye surgery in 1992, the complainant irritating irritation and caused by the loss of structure in 1995, just where the removed assistance and the medicine given, the complainant treatment was no relief, had no relief, but the nothing is so the medicine was not given a proper treatment, no expert evidence or no medical lecturer to counter the material on the record of result of the complaint. That has to completely prove the case of medical negligence, the complainant dismisses. As we have to go further on the judgment will be has same done NCDRC as per the first appeal number 431 by 2005 decided on 17th November 2009. The Consumer Protection Act 1986 section 2 clause 1 subclause G as per the 7 and 17 and 21. the medical and negligence. The treatment for the heart disease alleged the deficiency in the services, the dismissed by the state commission. The petition have suffered a 2 heart attack quickly, the successfully, but the operation had to be abandoned. And the blood was found in a pericardium, and the operation at the stage would be a dangerous to the life patient. The simple allegation of the as the simple way where the person have a blockage of 70%, the operation is not required to be a done. No medical expert leads to be a appellant complainant to be a submission. An allegation of the medical negligence. A doctor can be held guilty of medical negligence on the conduct of fail to shot below the standard of the reasonable competent to the doctor in the field. The blood in a peridium cannot be detected without opening the heart. The respondent not guilty of medical negligence in a deficiency in a service. The appeal is dismissed. That's it. And further we do the first, last and the final expert opinion in this, the Consumer Court Act as per the NCDRC, as per the revision petition number 170 of 2006 decided on 21st October 2009. The Consumer Protection Act section 12 and 17, the medical negligence, the child in a warm dye and photos remove the negligence and deficiency allegation on a plema that after examining the ultrasound report, the respondent doctor prescribed the medicine through form ultrasound. It was clear that the child is already died. The district form allowed the complainant to award it the compensation. The state setting aside the judgment, the revision to be proved a medical negligence was not the complainant. Heavy duty was the cast on the complainant to prove it the expert medical evidence. The medical practitioner could not held liable simply because things went wrong. Because the error of the judgment in choosing a particular courses, the treatment, no evidence, the conduct of the respondent fell below the of the standard of the reasonable competent the practitioner in the field. No reason to interference. Let me go through the where we can file a case for the medical negligence. We can file a case in a consumer court. We can file a case through FIR, do a FIR way of the criminal case. Third, we go through the Maharashtra Medical Council, and we can go for the appeal for the Indian Medical Council if the Maharashtra Medical Council reject for that. And further, for the appeal, if the Medical Council also reject, also we can go through a Supreme Court for that. Whether we could, let me discuss the first, the consumer court. It will define as we want the reasonable degree of a care, skill, willful negligence on the part of medical practitioner. It the treatment of the patient with the whom a relationship of the professional attention is established has a lead the bloodly injury or loss of life. The absence of lack of care that the reasonable person should have to be a circumstances of the case has a held to be a negligence by the three ingredients are to be a followed: the deficiency, own duty care, plaintiff had the deficient duty care, plaintiff suffer the injury due to a breach. Further, where to file a complaint? Let me discuss on that. The person can be file a complaint in a district consumer dispute redressal up to the amount is through 1 crore. Further, we go to a state consumer dispute redressal is up to 1 crore, 1 to 10 crore. Further, we go to a national consumer dispute commission. The value is up to as per 10 crore above. As per the rules, as per the 2000 Act, as per the Consumer Protection Act 2019, as per that to file a complaint as per the amount to be arranged by that as per the act. The complaint. The first case In the Supreme Court of India, the civil jurisprudence, the civil appeal number 2867 of the 2012, the Supreme Court, it the judgment on hence the compensation of rupees 1.73 crore, which was awarded by the National Consumer Dispute Redressal Commission in 2012 to the tune of rupees 5.96 crore, asked to Kolkata based Advanced Medicare Research Institute and the doctor to pay the amount. Also asked to pay the interest rate of interest of rupees 6% from the date of filing the complaint in 1999 till actual date. The payment of Kunal Shah, a US based Indian origin, the doctor for the medical negligence which held the death of his wife in 1998. When we go through the where the person in this the case the expert opinion is done, so that it help to the people who have to need further the case should be proceed. The medical expert opinion is necessary for that as per me. And the further we go through the guidelines which we provide by the Supreme Court, the status of qualification of the victim and her husband. Second, the income of standard of a living in the USA, economic expert for the USA, scientific calculation of the loss income of the claimant. Further we go, in this case the loss of his wife to the husband may always truly compensate by the way. The mandatory compensation, how could we have a code the long time? The compensation husband lost his wife. Therefore, the court consider the loss of income family. It may be a difficult to when she have earning. Even otherwise, the wife is a contribute the last contribute in the family role. It's not in we cannot consider in a term in money. The family term in money cannot always work out. Every housewife make a contribute in a family. It will be capable being a major and monetary term. Although the emotion aspect it cannot depend upon the education qualification is her own upbringing, the status, husband income, etc. Further, we go to the NCDRC of New Delhi. As per that, appeal number 685 of 2006 decided on 21st September 2016. The Consumer Protection Act, as per the section 17, 19, 21, the medical service, the medical negligence, the fracture of the complainant allegation due to the negligence of the OP has suffered the 50% of his leg because of handicap, compensation of rupees 3 lakh awarded the state commission. Had proper diagnosis has been given the first day itself, the proper could be have started day onwards. It can be stated suddenly whether and result would have the better otherwise, but the whatever was expected from the doctor specialized in the field which does not appear even it done. The OP doctor guilty of medical negligence, the score or has a failed to exercise the reasonable care of the patient expected from the professional, like the compensation of rupees 3 lakh awarded by the state commission reduced to the 1 lakh. Let we go to the third judgment. National Consumer Dispute Redressal Commission, as per the revision petition number 48 by 2007. The Consumer Protection Act 1986, the section 2 clause 1 subclause D, the complaint maintainable, the medical negligence husband of the complainant is the government servant, and the event through she receive a treatment free of charge in a government hospital. He would be a treated the consumer where the service is rendered as a part of term of service would not be amount of the service and would be a constitute the service for the purpose of the consumer to be protected act. And the further is the Supreme Court of India, as per the civil appeal number 317 of the 2009 decided on 19 January 2009, the Consumer Protection Act section 23, the medical negligence appellant claimant for the compensation of rupees 10 lakh allegation that the account of negligence the respondent maintained mentioning the wrong blood group in a report of his laboratory. As a result, the wife has suffered a 2 abortion complaint dismissed the state. Abortion complaint dismissed the state. The commission dismissed the complaint. The national commission granted the compensation of rupees 25,000 plus interest of rupees 9%. Holding this was the total failure of the part of the respondent in exercise adequate care. Analysis of the blood held the circumstances of the case. The compensation of rupees 1 lakh with the interest. And we go to the further judgment of the Andhra Pradesh State Consumer Dispute, where the CT scan were giving the wrong report. In that, the Consumer Protection Act, as per the Andhra Pradesh State Consumer Redressal Commission, as per the CC number 11 of 2000, decided on 15th August 2010, where the Consumer Protection Act Section 2 Clause 1G and Section 2 Clause 1O and 17, the medical service medical negligence. The wrong CT scan, if there is no evidence to show OP omit the brain scan complainant. On second occasion, on the oral advice, the doctor OP has guilty of negligence in omitting for the brain scan. The complaint on a second occasion that thereby the deficiency in a service. The complainant had diagnosis with the spread of disease, brain, another hospital, relevant in the MRI report amount of rupees 50,000 if awarded to the all count, with to be meet to be end of justice. The complainant allowed to liberty to OP allegate there the grievances against the insurance company in appropriate form. OP direct to pay the amount of rupees 50,000 with the cost of rupees 5,000. Go through the judgment of the National Consumer Dispute Redressal Commission of New Delhi as per the interim application number 4776 of 2013. The condition of the delay decided on 23rd May of 2014. The Consumer Protection Act 1986, the Section 15, 17, 19, 21, the service, the medical negligence, the death of the patient. The Tax Commission reduced the amount of compensation of rupees 5 lakh to the 1 lakh. The patient was no the case of hypertension and diabetes. She has already running with the high fever. It have a brought to be a hospital opposite party doctor when the patient was referred to the Roshni hospital. She have a diagnosis has a suffering for the malaria and the treatment was stated from the disease, but the state of vital part is already because of she have died multiple organs of failure. The post-mortem was done on the body of disease. The cause of death was to be known. The charge of negligence against the doctor has not been sustainable by any evidence. There is maybe an error of judgment reaching correct conclusion about the proper diagnosis. Against the doctor not be a sustainable detect that the case of cerebral malaria, it does not sound worse at the charge of doctor with the negligent deficiency in the services. The charge of medical negligence against the opposite the party doctor does not stand to be a proof. The passed by the state commission as well as the district form are setting aside. Further, we go through the second aspect of the criminal cases. The criminal having case against the medical professional found grossly negligent, the responsible for the patient death in IPC as per the legal basic holding the medical professional is liable for the action of omission as per the section 304A. Now as per the section amendment has been carried on as per the section BNS Bharatiya Nagrik Sanhita of 2023 as per that section 106. The section deal with the case where the medical professional riskless or the careless conduct of the result in a patient death. The punishment of the offence is to be a 2-year imprisonment or fine. The standard proof for the criminal liabilities in a high require the high degree of risk as the gross negligence. The court held that though some guidance to be case to be brought by the 304, but still now we see as per the section 106 of the BNS of 2003. The anyone debt as per the divided in two parts. As per the part 1, anyone caused death by the negligence up to 5 years imprisonment or fine. Or second part, the registered medical practitioner caused death by the medical during the medical procedure up to the 2 years of imprisonment or the fine. The Indian Medical Association raised the concern the law arguing the case could be a lead the doctor practicing deficiency in medicine, avoiding high risk patient IMA as liable for the law controversy, and there is legitimate the case of exemption the doctor from the criminal procedure prosecution. I may also highlight the section 26 of the BMS Act of 2023, the some protection of act that not indeed the cause of death and the done in a good faith a person benefit. Further we go through the judgment of them. First, the judgment of the High Court of Delhi, New Delhi, as per the Ramesh Das Sharma of versus Medical Council of India, had order on 19th September 2019. As per the judgment, as we go through the judgment, the criminal, if there is a medical negligence done by the treat, as per the petition wife, according the petitioner have a criminal negligence, is performing a surgery procedure in his wife. Further claim is procedure and dismissed. dismissed. The case is related on the FIR. Exactly the procedure for the FIR to be done. How? In this case, the police, in this case itself, wait a second. In this case, expert opinion where the referred by the MNC, the reproduced by the minute of proceeding of the ethic committee. The plan reading the said the opinion or indicate the expert has not absolute respond on the report. In this case, in short way, we have to go through the in this the court finding unanimity the police authority to proceed in the view of express to the MCI Delhi DMC or MCI in this case, because the police have no sense of the medical negligence, what to do and how, what the terms of medical way, they didn't know about that. So the in this judgment, the police in this judgment the court said we need the expert opinion from the MNC or the DMC where the people can know about the further procedure. The police so that able to investigate the further procedure in this case. Further we go through the High Court. Further we go to the judgment of the Bombay High Court. The writ petition number 377 of 1987 decided on 23rd December 1998. The article 226 of medical negligence or the petitioner doctor complain against the state medical issuing the so-called notice, the challenges and object, issuing the particular member inquiry proceeding held of the Justice Council direct to hold the inquiry affordable opportunity to petitioner without participating being a concept against the petition by issuing a so-called notice, such the inquiry necessary for in the public interest in a law confidently of the public in a medical profession. In this case, the inquiry conduct against the petitioner suffering for opportunity to be heard. Hence, then we have to know the maxim or the alterum partum. To hear both the side, the party should have to hear both the side. It's in this. It's the same maxim is to be applied in this case. In the fact is that the interest of the petition as well as the merit is so there was no professional negligence or misconduct on the part. If would be, however, the open petitioner, the contention before medical council, the material rely on the medical council for the purpose for issuing the court short notice is not sufficient to hold discriminatory inquiry against him. Has been finished on the criminal. Now go through the medical council. As per the medical council, the Maharashtra Medical Council. First, as per that appeal will we go to the Indian Medical Council and we go to the Supreme Court. Let me discuss on the third topic on the Maharashtra Medical Council. First we go through the Maharashtra Medical Council. The person can go for the approach to the Maharashtra Medical Council. For that, the medical practitioner have a negligence against me. so that the medical council may be substance their license on the what the procedure and what the section are to be there, which we know. The further, first we know the who are not come under the Maharashtra Medical Council. DMA, BMS, BH, the degree has to be a there, not come under that. Homeopathy, DMA, BMS, BH, MAS, they are not come under, the complaint can be filed against them. Hence we further how to file a complaint against the doctor. First we know the doctor report which to be there, so that we could have a evidence to be a proper way, so can we complain against them. First we have to affidavit is the format way, there the MNC have given in a portal. First we have to download the undertaking and notary to them, and further we take a step, and second step further we have to attach with the document which are necessary for that, like blood report which are to be known to you, which are the impact on the medical negligence. On the basis of that you have to attach that and send it to the Maharashtra Medical Council by the speed post. Further we have to take the the committee has been established on the basis of that, and conduct the both the side, have we know the maximum of audi alterum partem to hear both the side, and further the proceed to be done, and further both the side the doctor also filed a reply on that, and further proceed to be done, and within as per that the evidence on the both the side has been done, and the argument and the judgment order may be passed by the MNC. On the basis maybe doctor may be guilty, if no, if guilty the doctor license may be sustained as per the MNC. Further we go through the if what the appeal should be there. Appeal the if we agree or not agree. If we agree, the appeal within a period of 60 days is to be done as per the rule. And what the procedure are to be followed in the stead. MNC Act 19 Maharashtra Medical Council Act 1965 and Maharashtra Medical Council rules of 1967 govern the process of complaint against the registrar. MNC rule cover the process of the inquiry against the medical practitioner. As per we go through the as per we go the Maharashtra Medical Council rules 1967, as per that section 62 start the inquiry. For that the what already have a talk against the medical practitioner, how to conduct the complaint and so, and further we appeal as per the section is clearly specified. And this that also the form 18 is to be there, the notice is sent to the medical practitioner in a simple way. The form 18 itself in the medical Maharashtra Medical Council rules in 1967. Further we go through the last and the final part of the conclusion. The medical professional is the one of the oldest profession of the world and the most humiliated one. The inheritance of the professional code conducting a basic ethic underlying the moral value. The medical ethic underpin the value of his heart from the practitioner to client the relation. The recent time the professionally developing the tendency to forget to self regulation to from the which is at the heart of the professional. It is the privilege and not the right of the professional to obtain the privilege in a return for the implied contract with the society to prove the good, competence and accountability and service to the public. It must always keep in the mind that the doctor is a noble profession and the aim must be a serve to humanity, and otherwise this dignity professional will lose the worth. Further, the last point we discussed, through the doctor seen me a good patient believe they are will be a better treatment, that the would be handle the treatment provide, but the something has happened, even the doctor make a mistake with the cost lot of the patient may be away many way. To some instant the mistake made the are to be so dangerous to the patient have to pay prescribe under gone the suffering. The uses of equipment, tools, healthcare, doctors should be a made duty care the lead the injury to the consumer, which may be further result of filing of complaint against the doctor and other authority. At no provision can be made the manufacturing the equipment unfitted equipment liable for the damages. Another important concern the service render charges exceeds the scope of Consumer Protection Act. This is create the problem to the patient and go through the BNS as per the we go through already. The BNS introduced by the medical negligence concept to improve the health and safety to standard and accountability for creating a fair, effective legal system. The concern of the both patient and the doctor have to be addressed. As we already go through the another concern, the service. Only the last point I wish to say, the doctor are like a god on a planet because they are the one who bring the life and joy to in our life. That's it. Thank you.
Sumit, thank you very much. It was a nice to hear on a topic of your choice, that insights into medical negligence, because this is one of the topic which is going to be a very long term practice for people, because medico legal is becoming a profession now. So thank you very much for being our guest. So this is a small token from us to you.
Thank you.